Hello friends, imagine spending years building your career in the United States. You follow every rule. You work hard. You pay your taxes. Your employer believes in your future and begins sponsoring your green card. Finally, it feels like your dream is moving forward. Then one morning, you receive an update that changes everything. Not because your case was denied. Not because you made a mistake. But because another full year has quietly been added to one of the most important steps in the entire process. For thousands of skilled workers and their families, that is no longer a hypothetical situation. It is becoming reality. But here is what most people still do not realize. The latest update from the United States Department of Labor confirms that processing delays for PERM labor certification applications remain extremely long. For many applicants, average analyst review times continue to exceed 1 year, even before they can move to the next stage of the employment-based green card process. That means many workers who expected steady progress may now face months of additional uncertainty before their cases even reach USCIS. If you are currently working in the United States on an H-1B visa, an L-1 visa, or another employment-based status, this update could directly affect your future. It could influence your green card timeline, your career opportunities, your family's long-term plans, and how long you remain dependent on temporary immigration status. And this is exactly why today's update deserves your attention. Many people hear the words green card backlog and immediately think about visa bulletin delays or waiting for a priority date to become current. Those are certainly important. But what many applicants overlook is that some of the longest delays are now happening much earlier in the process, long before an immigrant petition is filed with USCIS. To understand why this matters, let's briefly look at what the PERM process actually does. Before many employers can sponsor a foreign worker for permanent residence, they must first obtain an approved permanent labor certification from the Department of Labor. This process is designed to protect the United States labor market by confirming that there are no qualified and available United States workers willing to fill the position under the required conditions. Employers must also demonstrate that hiring a foreign worker will not negatively affect wages or working conditions for similarly employed workers. In other words, PERM is not simply another form to complete. It is one of the most critical foundations of many employment-based green card applications. Without an approved labor certification, employers generally cannot move forward with filing Form I-140, the immigrant petition that allows many applicants to continue their path toward permanent residence. This is why the latest Department of Labor update is receiving so much attention. According to the agency's current processing information, many applications continue waiting well beyond 1 year for analyst review. If an application is selected for an audit or requires additional review, the overall timeline can become even longer before the employer receives a final decision. That does not automatically mean something is wrong with your case. In fact, this is where many people make a mistake. After waiting several months without hearing anything, some applicants begin believing their application has been lost, denied, or forgotten. While individual cases can certainly have unique issues, a long wait by itself does not mean your application is in trouble. In many situations, it simply reflects the significant workload and processing backlog currently affecting the Department of Labor. Even so, knowing that your case is delayed does not make the waiting any easier. Behind every application is a real family trying to plan its future. Some families postpone buying their first home because they do not know where they will ultimately settle. Others delay career opportunities because changing employers at the wrong time could affect parts of the green card process. Some parents worry about their children's future immigration options as the months continue to pass. And many workers simply wonder when life will finally become predictable again. The emotional side of immigration is something processing reports rarely show. Government statistics can tell us how long applications are taking, but they cannot measure the stress of putting major life decisions on hold while waiting for progress that seems to move slower every month. What makes this update especially important is that these delays affect more than just one group of applicants. Technology professionals, healthcare workers, engineers, researchers, university employees, financial specialists, manufacturing experts. Thousands of highly skilled workers across many industries depend on the employment-based immigration system, and when one stage slows down, the effects spread throughout the entire process. For applicants born in India, the situation can be even more challenging. Many Indian professionals already face additional waiting because of annual immigrant visa limits and high demand in employment-based categories. When the PERM stage itself now stretches beyond 1 year, the overall journey toward permanent residence can become significantly longer than many families originally expected. This is why understanding today's update is not about creating fear. It is about replacing uncertainty with preparation. Because what happens next is where many applicants accidentally create problems for themselves. Some assume they should simply wait and hope everything works out. Others make major career or travel decisions without understanding how their immigration timeline could be affected. And in some situations, those decisions can create unnecessary complications that add even more delays. Fortunately, there are practical steps you can take to protect your immigration journey while these backlogs continue. But before we get there, there is another part of the green card process that many applicants misunderstand completely. And once you understand how these delays affect your visa status, your employer, and your future options, the Department of Labor's latest update will make far more sense. Now let's talk about what these delays actually mean for you, because this is where the situation becomes much more personal than many people realize. For most applicants, waiting is frustrating. But waiting without understanding the consequences can be even more dangerous. A green card is not just another immigration document. For many people, it represents stability. It represents career freedom, long-term security, and the ability to plan a future without constantly worrying about the next visa renewal. When one of the earliest steps in that journey suddenly stretches beyond 1 year, the effects reach much further than a processing timeline. One of the biggest concerns is maintaining lawful immigration status while your green card case slowly moves through the system. Many applicants are currently working in the United States on H-1B visas or other temporary employment-based visas. Although immigration law provides important protections for many workers pursuing permanent residence, those protections often depend on meeting specific legal requirements and filing deadlines. This is not something to ignore. Most workers do not realize this until it becomes a problem. Some assume that once their employer starts the green card process, everything else will automatically take care of itself. Unfortunately, that is not how the immigration system works. Even while your PERM application is waiting, your temporary immigration status must still remain valid. Visa renewals, employment authorization requirements, passport validity, and other immigration obligations continue exactly as before. The green card process does not pause those responsibilities. This is why staying organized has become more important than ever. Keep copies of every approval notice. Save every receipt. Track important filing dates. Maintain regular communication with your employer's human resources department or immigration attorney. Small details today can prevent major problems months later. This small mistake can create serious problems later. Another issue many applicants overlook involves changing employers during the green card process. Imagine receiving an attractive job offer with a higher salary and better benefits after waiting more than a year for your labor certification. Naturally, accepting the offer may seem like the obvious decision. But depending on where your case stands, changing employers could affect your green card strategy. In some situations, a new employer may need to begin parts of the employment-based immigration process from the beginning. Every case is different, which is why applicants should understand the immigration consequences before making major career decisions. This is where many people make a mistake. They focus only on the opportunity in front of them without considering the immigration timeline they have already invested months or even years building. The right career move should support your future, not accidentally delay it. Family planning also becomes much more difficult during extended processing delays. Imagine trying to decide whether to purchase your first home. Should you sign a long-term mortgage? Should your spouse change jobs? Should your children transfer schools? Should your family make long-term financial commitments? These are normal decisions that millions of families make every year. But when your immigration future remains uncertain, each decision carries additional weight. For many families, the hardest part is not simply waiting. It is living without knowing when the waiting will finally end. Employers also face significant challenges. American companies invest considerable time and resources sponsoring international talent. Recruitment must follow Department of Labor regulations. Prevailing wage determinations must be completed. Documentation must be carefully prepared. Every required recruitment step must be documented before filing a PERM application. If mistakes are discovered later, correcting them may take additional time and expense. That is why employers are paying very close attention to the latest Department of Labor processing updates. Longer delays make workforce planning much more difficult. Companies may need to extend temporary work authorization strategies, adjust hiring plans, and coordinate closely with Immigration Counsel to ensure employees remain eligible to continue working legally. Another important issue involves audits. Hearing the word audit often causes unnecessary panic. But an audit does not automatically mean your employer did something wrong. The Department of Labor conducts audits for different reasons, including quality control and verification that recruitment requirements were properly completed. If your application is selected, additional documentation may be requested before a final decision is issued. While this can increase the overall timeline, it should not automatically be viewed as a negative outcome. Responding completely and accurately is usually far more important than responding quickly. There is another misunderstanding spreading across social media that deserves attention. Some online posts claim that long delays mean the government has stopped processing green card applications altogether. That is simply not accurate. Applications continue moving through the system. The challenge is that processing demand remains high, creating longer waiting periods for many applicants. This is exactly why relying on official information matters so much. The Department of Labor regularly updates processing times, while USCIS continues providing case status tools and official guidance for applicants moving through later stages of the employment-based immigration process. Another point that often creates confusion is what happens after PERM approval. Many applicants believe approval means their green card is only weeks away. Unfortunately, the process is usually much longer. After an approved labor certification, many employers still need to file Form I-140 with USCIS. Then, depending on the applicant's priority date and immigrant visa availability, there may be additional waiting before adjustment of status or immigrant visa processing can begin. For applicants born in countries with high demand, especially India, visa availability under existing federal immigration limits may extend the overall timeline even further. Understanding this larger picture helps reduce unnecessary frustration. The current delay is significant, but it is only one part of a much longer immigration process. The good news is that there are practical ways to protect yourself while waiting. Stay informed using official government updates. Keep your immigration records organized. Maintain valid temporary status. Discuss important career decisions with your employer before making changes. And avoid making life-changing decisions based only on rumors circulating online. Because what happens over the next several months could shape your immigration future for years to come. And there is one final part of this story that every green card applicant needs to hear. It is not about another delay. It is about how you can prepare, stay ahead of the process, and avoid the costly mistakes that continue catching thousands of applicants completely by surprise. So, after everything we have discussed, one question still remains. What should you actually do if your green card case is caught in this growing PERM backlog? The answer is not to panic. It is not to assume your application has failed. And it is certainly not to make important immigration decisions based on rumors shared across social media. Instead, this is the time to become more informed than ever before. One of the biggest advantages you can have during a long immigration process is understanding exactly where your case stands. Ask your employer whether your PERM application has already been filed. Know your filing date. Understand whether your case is still waiting for analyst review or whether additional information has been requested. If your employer is working with an immigration attorney, do not hesitate to ask for updates whenever appropriate. Good communication often prevents unnecessary confusion. Another important habit is checking official government updates instead of relying on online speculation. The Department of Labor regularly publishes processing time information, allowing employers and applicants to understand how current cases are moving through the system. Likewise, USCIS provides official guidance for later stages of the employment-based green card process, including Form I-140 petitions and adjustment of status applications. These official resources may not always deliver the news people hope to hear, but they provide something even more valuable. Reliable information. And in today's immigration environment, reliable information is one of your greatest tools. Another area that deserves careful attention is your temporary immigration status. Many applicants become so focused on their future green card that they unintentionally overlook the visa they currently hold. Do not let that happen. If you are working under an H-1B visa or another employment-based status, continue following every requirement attached to that status. Renew documents when necessary. Keep your passport valid. Maintain accurate employment records. Report required changes through the proper legal channels. Remember, your temporary status is what protects your ability to remain and work legally in the United States while your permanent residence application continues moving through the system. This is not just paperwork. It is the legal foundation that supports your entire immigration journey. Financial planning is another issue many families rarely discuss until problems appear. Because green card timelines have become more difficult to predict, families should prepare for the possibility that temporary visa renewals, legal services, government filing fees, or relocation plans may continue longer than originally expected. Planning ahead financially can reduce unnecessary stress if processing takes additional months. The same principle applies to career planning. If another employer approaches you with a promising opportunity, pause before making a decision. Ask how changing employers could affect your green card strategy. Sometimes accepting a new position is absolutely the right move. Other times, waiting a little longer may protect years of immigration progress already made. Every case is different. That is why personalized legal guidance is often far more valuable than general advice found online. There is another important reminder that many applicants need to hear. Long delays do not erase the progress you have already made. It is easy to feel discouraged after waiting month after month with very little visible movement. But every completed step still matters. Your employer has already invested time, resources, and effort into your future. You have already followed the rules. You have already moved closer to permanent residence than many people who have not even started the process. Progress may be slower than expected. But slow progress is still progress. That perspective can make a tremendous difference during a long immigration journey. Looking ahead, many immigration experts believe employers, applicants, and policymakers will continue paying close attention to Department of Labor processing times throughout the remainder of 2026. Businesses depend on highly skilled international professionals. Universities depend on researchers. Hospitals depend on physicians, nurses, and healthcare specialists. Technology companies depend on engineers and software developers. The employment-based immigration system plays an important role in supporting the American economy, which is one reason these processing delays continue attracting national attention. Whether future improvements arrive quickly or gradually remains uncertain. What is certain is that applicants who stay informed will always be better prepared than those who rely on assumptions. So let us bring everything together. The latest Department of Labor update confirms that many PERM labor certification applications continue experiencing processing times exceeding 1 year before reaching the next stage. That means many employment-based green card applicants should prepare for longer timelines than they may have originally expected. However, a longer wait does not automatically mean your application has been denied. It does not mean your employer made a mistake. And it does not mean your green card journey has come to an end. It simply means your case is moving through an immigration system that continues managing a substantial workload. Your responsibility now is clear. Stay informed. Keep your documents organized. Maintain your lawful immigration status. Communicate regularly with your employer. Verify important information using official government sources. And think carefully before making major career or immigration decisions while your application is still in progress. Those simple actions can help protect years of effort and reduce the risk of avoidable delays. Immigration has always required patience. But today, patience alone is no longer enough. Preparation, accurate information, and careful planning have become just as important as the application itself. If you know someone waiting for a green card, especially a friend, family member, or coworker whose future could be affected by these continuing PERM delays, share this video with them. It may help them avoid common mistakes and better understand what these latest Department of Labor updates really mean. And if you want clear, accurate, and practical updates on United States immigration, green cards, visas, travel policies, and government changes, make sure you subscribe and turn on notifications so you never miss an important update. Thank you for watching, take care of yourself and your family, and we will see you again in the next update.